Continuing coverage now on today's U.S. Supreme Court ruling as it relates to the power of presidential executive orders, what it means and what it doesn't. Joining us now is veteran political analyst Linda Shatt, a former aide in the Carter White House. Linda, the ruling today says federal district courts had exceeded their authority when they had issued nationwide injunctions on executive orders. President Trump's calling this a victory, but it doesn't mean necessarily that presidents can do anything they want with the executive order. Please, explain that.
I'll try to. Supreme Court decisions have suddenly become political events, right? And this today was no different. What the court did was avoid a direct showdown with the administration on birthright citizenship, but it empowered him in a different, perhaps more sweeping way by saying that the lower courts could not put in place a national injunction. And so what does that mean? It means that executive orders may be upheld by courts in one part of the country, but not in another. And it also means, as you said, that the president can't, in a very sweeping way, do away with the Constitution with an executive order.
And having said this, the question of birthright citizenship will come before the high court. This just isn't it, which I fear some people think it has.
I think you're right. And we have to remember that the Supreme Court has affirmed the principle of birthright citizenship as guaranteed in the 14th Amendment many times, including for children born to immigrant parents, regardless of their immigration status. So they didn't even address that constitutionality issue today, only whether or not a president's executive order could be held up by one lower court with a nationwide injunction.
Now, having said that, am I correct in assuming that if a number of the district courts across the country, or all of them, were in lockstep and they all ruled against the order, then we could at that point have a nationwide order, but no one of them can do it alone?
No one can do it alone, and you would have to be nationwide, it would have to cover all of the districts, all of the states. The way that I think this will come about, however, is through a nationwide class action suit that will make its way to the Supreme Court, and that's where the Supreme Court will have the final say.
And we should let people know the High Court did make a ruling today that parents like those in Tennessee can opt out of their children being in classes that have LGBTQ characters, and the right, of course, is claiming a victory there.
That's right, and they should. This conservative court has consistently reinforced the idea of religious liberty and has sided with parents in cases where that issue has come up.
Veteran political analyst Linda Shatt, as always, thank you much for sharing your thoughts.
Thank you.